Everything has an expiration date. Milk, medicines, lawsuits, especially lawsuits. If you miss the expiration date on your lawsuit, you could be forever barred from pursuing your claim. Now, those are called statutes of limitations. I'm going to talk to you about what those are today, why they exist, and how in certain circumstances, those expiration dates could actually be put on pause. My name is Shanik, rhymes with Sonic, and I've been a plaintiff's litigator for almost 10 years. That means that I represent people, usually against big corporations or government entities, and I love the law, and I love using it to fight for people every day. When somebody comes to me with a potential case, one of the first things I clock is how long ago did this thing happen to you? Because as soon as I know that, I know how long they have to file a lawsuit. Every single different type of claim they might have under the law has a different statute of limitations, a different period of time that the law says they have to file suit in court in order to protect their rights. Some of these statutes of limitations are really short, like 6 months. Others are long, decades. It really depends on what the legal claim is. There really is no uniformity in how long these statutes of limitations are. They vary wildly from state to state, from state law to federal law, and even based on the substantive claim within a state. The clock on your statute of limitations starts running on the date of accrual of the claim. The claim starts accruing when every legal element of that claim is met. For example, the elements of a negligence claim are that the defendant had a duty, the defendant breached that duty, the plaintiff was harmed, and the defendant's breach of their duty was a causal link to the harm. Because harm is generally an element of every legal claim, and usually the ultimate element in that claim, it's the last thing to happen before all the elements are met. Harm is usually when the statute of limitations date starts ticking. It's when the claim begins accruing. So you can think of it as when the person got hurt is when the clock starts ticking. So for example, in California, in a personal injury case, say a trip and fall, you have 2 years from the date of injury to bring your lawsuit. Now, accrual is a little bit different if there are continuing violations. So take an employment case where somebody is a victim of wage theft and they are not getting paid overtime. Every paycheck, they are denied their overtime that they're owed. Well, every paycheck is a different instance of the harm. It is a continuing violation that is continuing through their employment. So the statute of limitations doesn't begin running from the first time that it happened. It continues running from the last time that it happened. And so if this has been happening for years and years, what would normally in California be a 3-year statute of limitations for wage and hour claims, well, that clock wouldn't really start ticking until the last point in time at which the employer denied the wages. And so you can see that harm, for the purpose of when a statute of limitations starts triggering, isn't limited to physical harm either. It's very dependent on what the claim is. Supposing somebody breaches a contract, oftentimes the harm there is the breach itself, the failure to do the thing they were supposed to do under the contract. Regardless of whether there was some additional harm that resulted from that, some additional damages, the harm for the purpose of the contract claim is the breaking of the contract. And that's the date at which the statute starts running. One of the things that really makes my hair stand on end is when somebody comes to me and says something happened. And I look at the date that it happened and I realize that there's a very, very short time before their case has to be filed or they are precluded forever from bringing a cause of action. That happens a lot when people are trying to sue government entities in California. If you're suing a public entity, a government entity, whether it's the state of California, the Department of Transportation, Caltrans, local municipality or school district, you only have 6 months to bring your claim. If somebody's lost a limb or lost a loved one or suffered a life-changing incident, forcing them to find a lawyer, hire the lawyer, talk to the lawyer about their case, and have the lawyer file a legal claim all within 6 months from the day it happened, it is far too much of a burden to place on somebody who may still be trying to process what happened to them. And yet, the state of California has determined as a policy matter that 6 months is the date. All statutes of limitations are based on policy determinations, a weighing, because at a certain point in time, it has been long enough that for a particular claim, the burden on the defendant of having to investigate and defend against that claim when no evidence may exist far outweighs the benefit of allowing the plaintiff to pursue that kind of claim after so long. Say that you, as a 35-year-old, get sued for a fender bender that you were involved in when you were 16. You don't remember what happened. You don't remember the road conditions, where you were driving. You don't have the car anymore, and there's no way to know what's happened to the car. There were no insurance claims filed, so there's no documentary evidence. And all you really have is this person suing you who says that it happened. At that point, forcing you to defend yourself in court when you can't even do a thorough enough investigation to conclusively deny the allegations is too high of a burden as compared to what the benefit is, which is allowing somebody who was involved in a fender bender to file suit. And this weighing of burden versus benefit is why statutes of limitations vary so wildly from claim to claim and even state to state. A perfect example is what happened after the Me Too movement. After that, states like California and New York passed laws greatly extending the statute of limitations for sexual assault claims. They decided as states, as societies, that the burden of having an accused defend against a sexual assault claim from years and years ago was still not high enough to overcome the benefit of allowing survivors to pursue claims years later. And part of that was a recognition that there are valid and legitimate reasons that survivors don't promptly come forward after they've been sexually assaulted. It is a very policy-centric analysis that is generally dependent on the severity of the claim. It's why, for example, murder generally has no statute of limitations. We have decided that murder is so bad that no amount of burden or prejudice of having to defend against murder is sufficient to overcome the benefit society gets from having murder prosecuted, even if it's years and years later. But even a short statute of limitations isn't inevitable. There are times when that clock can be paused for a longer period of time. The doctrine of pausing the clock is called tolling. A statute of limitations is tolled, and it can be tolled in a few different ways. Statutory tolling, which means there is a law in place that says when certain things are met, the clock pauses. Equitable tolling, which is courts can decide in the interest of fairness under the circumstances, the clock should be paused. And tolling by agreement. Both sides agree, hey, let's pause it. Maybe they want to discuss settlement, and there's a time pressure, and they want to do it before the case gets filed. There are reasons why parties may agree to execute an agreement, putting that clock on pause for some period of time. Some reasons for statutory tolling could be if somebody is a minor, their claim may not start accruing. That clock may not start until they turn 18. If somebody is on active duty military service and they're out of the country, that clock may be paused for the pendency of while they're out serving our country. If somebody is mentally incapacitated, if they're in a coma, that clock might be paused until they regain consciousness or regain mental capacity. A court can equitably toll a statute as well. It can decide under the circumstances of that case that there should be a pause on the statute of limitations. For example, if the defendant has fraudulently concealed something that is relating to one of the elements of the claim, so that claim couldn't start accruing, or the plaintiff could not reasonably find out about all the elements of the claim for some period of time, a court might find that, okay, we've tolled the statute for that period of time where it was concealed. Relatedly, there's something called the delayed discovery rule, which is that if the plaintiff doesn't find out about their injury until years later, then oftentimes that statute won't start running until they learn of their injury. This is like in a toxic exposure case. If somebody discovers 5 years later that they've developed cancer because of some substance, well, the statute will start running from the date of discovery or the date they reasonably could have discovered that injury rather than from the date of exposure to the harm. And of course, parties can agree to toll the statute of limitations among one another. Suppose they want to talk about settlement and they want to do it before the plaintiff has to file the case. Once the plaintiff files the case, a whole lot of things get triggered, including costs to start racking up. And so they may want to avoid those and talk settlement while they can. So they execute an agreement and say, we'll toll the statute of limitations for 30 days or 60 days or 90 days so we can have these settlement discussions. One wrinkle is that the statute of limitations doesn't automatically apply. It is actually an affirmative defense that needs to be raised by the defendant, at least in most jurisdictions. And what that means is if the defendant doesn't say, hey, you can't bring your claim because the statute of limitations bars that claim, your expiration date has run. If the defendant doesn't say that, then the plaintiff is allowed to continue with their claim. And so defendants will often plead statute of limitations as a defense when they answer the complaint early in the case to make sure they haven't waived that argument for later down the line. A statute of limitations is one of many things out there that can stop somebody from bringing an otherwise valid and meritorious claim in court. If it's interesting to you, I've talked before about forced arbitration agreements and how those can actually prevent people from bringing claims in court, even if they're not really aware of what they're signing. So check out this video and you might find that interesting. Otherwise, I'm glad you stuck in there, and I'll see you next time.